Check.
Testing. Microphone testing. Microphone testing.
ఆడియో వస్తుంది రావట్లేదండి హలో చెక్ హలో టెస్టింగ్ హలో టెస్టింగ్ హలో 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 టెస్టింగ్ హలో హలో వస్తుందిగా చెక్ హలో
Hello.
Good evening, everyone.
Testing. Hello.
మన వాయిస్
Good evening, everyone.
ఇటు వాయిస్ రావట్లా
మనకు అవసరం లేదు కూడా
మన వాయిస్ వస్తుంది అవతల వాయిస్ రావద్దుగా మేడం
అవసరం లేదు. Please consider we are not allowing you to talk. నేను మాట్లాడుతున్న వాళ్ళతో and whatever the program it is happening here, you will get the live stream of same. And because of the some technical issues, we are not permitting you to raise the questions. And if at all any doubt you are having, please text to our number, organizer number, so that we can ask the speaker on your behalf. Your number is same?
మొబైల్ నెంబర్
Yeah.
మొబైల్ నెంబర్ వేస్తారు ఇక్కడ చాట్ లో పెట్టాము అంటే
Otherwise, text in the chat box so that we will inform the speaker about your question, so that he will clarify your doubts. You will have the access of chat box.
ఇప్పుడు షేర్ కి ఇక్కడికి వెళ్ళి షేర్ చేసాం ఆఫ్టర్
Sada.
Okay. పెట్టేసి.
Good evening, everyone. Good evening, everyone. Please be seated. The program is about to start. Thank you.
Hello. Good evening, all. Before we get started on the new criminal laws, Mr. P.V. Ramna Garu, Joint Registrar, is here. He will appraise us on how the new cause list and the new system works. So we have Mr. P.V. Ramna Garu here.
Respected President Garu and other bar members, we are happy to share with all of you. Just before vacation, our respected President Garu given one representation to the registry to incorporate some few features in the High Court official website. Accordingly, partly we have complied. We are happy to share with you, and we want to tell the features what we have given for the benefit of the land advocates. First of all, from the year 2019 January onwards, you can view the entire cause list of all the court, all the courts. Just select the accused button. No tax, no tax button. Please select the entire cause list. So there you will get in a calendar of the year. So you can select from the year 2019 on the select button. Please select the year 2019. 2019. So where the green buttons are there the cause list is available. You can see from the quotal number 1 to the last quotal. And there is a search facility also. You can search with case number, advocate name, or with the district name also. Next, you select year 21. The year. All the green color buttons are the cause list available. Now the last. The second feature is roster. If you click the roster, from 2019 onwards, whenever the rosters are changed, you can view the roster. So for example, 2019, 1st January, then 21st January, 10th January, 10th June. You can select year also similarly. 2020, you just select 2020. See, so many times in the year 2020, the roster was changed. So day-wise roster also you can select. And then second one, case status. Cases. In the case status, the respected president have asked to display the mobile number also of the advocate. We have displayed the mobile number of the advocate. Select the advocate. Year 2024. See, here you can see your bar registration number, and the second thing is your email ID and also your mobile number. So we request all the land advocates, if there is any typing mistakes are there or mobile number is wrong there, you kindly contact the registry, we'll correct it, and it is useful for your online CD and future e-filing purpose. So kindly request all of you check yourself with your code number. So it will display the mobile number as well as the email ID and your VAR registration number. If in case if VAR registration number is also wrongly typed, we'll correct it. Please kindly contact the registry. Thank you, my lord, and thank you, President Gar, giving an opportunity for tell all these things. Thank you so much.
Good evening, everyone. Good evening, esteemed judge, respected members of AP High Court Advocates Association, respected members, distinguished guests, and ladies and gentlemen. On behalf of AP High Court Advocates Association, I'm honored to welcome you all to the today's lecture on a new criminal law, that is Bharatiya Nyaya Samhita 2023, as part of continuing legal education. Continuing legal education helps the practicing advocates and the judges to stay updated with the latest development in the legal field. It will helps to understand the emerging areas of law and changes in legislation. A report by the central government, it says that the legal domain is an ever expanding body of knowledge. It is a lifelong learning process which makes a person expert to serve the demands of the profession. This program is part of our new initiative for continuing legal education, designed to keep our legal community updated on the latest legal developments. Today's session focus on understanding the recent developments in implementing the Bharatiya Nyaya Sanhita 2023. I take immense pleasure to invite the President of the Bar Association and Member Bar Council, Sri K. Chidambaram sir, to the dais, and I request you, sir, to adore the chair. We are also privileged to have with us a highly respected legal luminary, Honorable Sri Justice U. Durga Prasad sir. Please join me in welcoming Honorable Justice to the dais, and I request your Lordship to adore the chair. Now I request Srimati Aishwarya Nagula to present a bouquet to the Honorable Speaker. Have a big round of applause. I take privilege to invite Sri N. Srihari, General Secretary, AP High Court Advocates Association, as on the dais. I request you, sir, to adore the chair. Now I request President of Bar Association to proceed with the program.
Honorable Sri Justice U. Durga Prasad Rao Garu, General Secretary of the Association, N. Srihari, Executive Committee members of AP High Court Advocates Association, members of the AP High Court Advocates Association. Now today we have assembled here to hear the lecture on the Bharatiya Nyaya Sanhita 2023. The new act came into force from today. The central government has repealed the earlier IPC, CRPC and Evidence Act and introduced 3 new acts by name Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita, Bharatiya Sakshya Adhiniyam. All these 3 acts came into force from today. The AP High Court Advocates Association has decided to invite His Lordship Justice U. Durga Prasad Rao Garu to enlighten on the subject of Bharatiya Nyaya Sanhita. When we requested His Lordship readily accepted our invitation and ready to deliver his lecture on this subject. I do not want to waste your valuable time. Now I request His Lordship Justice U. Durga Prasad Rao Garu to give a lecture on this subject. Thank you.
Am I audible to all of you? Hello? Now, thank you. Yes. The President of the Bar Association, Sri K. Chidambaram Garu, the esteemed members of the Bar Association. At the outset, I must beg my excuse for having delayed you more than half an hour. In view of the inevitable delay, because today is the opening day of the week, so please excuse me if I delayed. The second thing, the Bar Association executive announced this as a lecture. Please don't think that it is a lecture. The three new major criminal acts have been enacted and they have been operated from today onwards. So they are only neonatal babies, Navajata Sisulu. We have neither the judgment law backed up nor any interpretation by the commentators, expert commentators on criminal laws, so that we cannot have a long discussion on them. Therefore, I feel that this is only a sensitization program, in the sense that what was the existing law till today and what is the new law that is coming, which we are going to operationalize it from today. And what are the basic differentiative features among them? And what are the criticisms already poured against the new enactments? Dear members of the bar, it is highly impossible to deal with all the three major criminal enactments today within this short time. Therefore, I will take up only one of the codes, that is the arrestable penal code, now in the form of BNS, that is Bharatiya Nyaya Sanhita. Sanhita means collection, a compilation. So Bharatiya Nyaya Sanhita, which has replaced the Indian Penal Code, I want to deal with some of the important provisions which we have to deal every day. Some of the provisions which have been newly introduced into the enactment which were not there earlier. Some of the provisions which were there, but because they might have been declared as ultra virus to the Constitution by the Honorable Supreme Court or some high courts, and thereby which they have been repealed. So our interaction or our sensitization program will go on in these lines. We will deal with some of the important provisions connecting to the BNS. Before I deal with this BNS, it is my duty, first of all, to sensitize the young and ebullient junior advocates. They need to sharpen their saw, their expressive skills, and their knowledge on the laws which they deal with every day. With my experience as an advocate cum judge for 40 years, I have seen so many laws which have emerged on the herald of the legal field in these 40 years. Say for few, in 1984, I commenced my practice. Immediately in 1987, I have seen amendment to the Nyaya Act. Isn't it? Chapter 17 has been introduced from section 138 to 148, making hitherto a civil law converted into criminal law by way of introducing section 138, making the check bouncing if a check were drawn and issued for discharging of a legally enforceable debt, if it were to be bounced back, isn't it? This is one legislation which we never thought of would come, but had come. Another social equalization enactment, which we thought that Section 7 of PCR Act would be sufficient, Protection of Civil Rights Act. But another social equalization enactment in the form of SC/ST Prevention of Atrocities Act 1989 has come on the herald. So on and so forth. These are only inclusive ones. If we take Motor Vehicles Act, 1937 Act has been repealed, 1988 Act has come, and in 1994 major amendment has come, taking away the jurisdiction as well as the limitation, isn't it? 1994 amendment. So what I want to impress upon the junior advocates is that law is not a static subject. Law is a dynamic subject. It tends to change. Whether we love or not, we will like it or not, it has to change to suit the requirements of the society. So in the process of the recent period, we have seen the most important technological law, Information and Technology Act, which has virtually shrugged the atlas, which has almost effaced the point of jurisdiction. The conventional type of jurisdiction has been taken away. If you read Section 75 of Information and Technology Act, isn't it? A person commits a digital offense sitting at the other end of the globe, and by holding your computer system or computer source at India or some other country and commits the offense, where the offense is said to have been committed either in India or elsewhere in the globe. So the jurisdiction has to be rewritten. Section 75 stated that if in India, so far as that act is concerned in India, so if the computer or computer system or computer resource or network is affected in India from elsewhere in the country, that offense can be said to have been committed in India. It can be taken to task as per Information and Technology Act. Why I am sensitizing you is, it is not as though young lawyers do not know. But my emphasis again is the law tend to change. Law tend to change. We have to keep abreast with the changing trends, emerging trends in the law. The last one, the next one, again, for easy facilitation of banks and financial institutions to recover their loans in an easy mode, which we never thought of in uh, years. I was specially a State Bank of India advocate, Andhra Bank advocate, standing counsel, I meant, and a state financial corporation advocate. I never thought of. One day would come that banks and financial institutions would be given power, legal power to declare a particular what you call account as an NPA, non-performing asset, and take over the mortgaged asset unto itself and put it in auction to realize its loan, isn't it? It was there only as a fringe in AP State Finance Corporation Act Section 29 or 30 in a limited sphere. But now under this Surface Act, that power has been given. You know, every day you have been arguing Section 13, 2, 4, 14, 17, 18, and so forth, so forth. So law changes. Law changes. We have to keep abreast with it. The last one, again, if you have to see, there are a number of enactments. These are all only inclusive laws, but not exhaustive. In the line falls now the three major criminal laws. The three major criminal laws have come into force from today onwards. This is an historical day in the sense all the three traditional major criminal acts have been given a go by. They were repealed and new enactments have come to, you all know, isn't it? So these enactments, of which I have already told that I will be dealing with only Bharatiya Nyaya Sanhita. Before I deal with these provisions in Bharatiya Nyaya Samhita, I earnestly believe the background history, at least in a thumbnail sketch, under what circumstances Indian Penal Code was legislated? What was its main ambition? What was its main intendment in legislating the Indian Penal Code? I believe if you're able to just walk back to the history, you will better appreciate why in recent times so much of criticism has been made against Indian Penal Code and why this law, new law, has been legislated in the form of BNS. You have to, for that purpose, you have to go back 1830, 35, 1780 also. 1830, at the time, Board President may excuse me if I have to deal with few minutes on the history of, and I may be taking your valuable time to go home and prepare for tomorrow. But tomorrow you have to deal with this enactment also. Therefore, I think I can consume your time for few minutes. Please bear with me. At that time, India was under the rule of British East India Company, isn't it? British East India Company mainly came to India only to do mercantile activities or business activities. But with the days passed on, with the effects of the time, because it had 260,000 of the military mighty force, having known how to use the gunpowder also, their military force was far exceeding than the Queen Elizabeth was having at that time. Such was a mighty force. East India Company, it was a registered company which has come to India to do business, and slowly it has captured certain pockets in India and started ruling. It was also doing the administrative activities along with the business activities at that time. This was at the time, it was a prelude for Indian Penal Code to be enacted. In the course of the time, it has concentrated only on the administration, ruling, etc., leaving the mercantile activities, business activities. Thereby, the British government felt that their business, their business interests have been adversely affected. At the same time, if you happen to be the reader of the world history, Napoleon was strong in French and Western European countries. He has given, they call it decrees or sanctions. Sanctions were given restraining the Great Britain from doing business in the Western European countries. So the British government has to seek for only Asian countries for developing the business. Why? Because industrialization has commenced in 1780 in Great Britain. Thereby, many cotton industries, mainly cloth industries, have come for which they need a market. India was considered to be a very good field for doing the business. Therefore, in around 1833, a very, very important legislation was made, which was also considered to be a prelude for our constitution in 1950. That enactment was called as Charter Act 1833. It was also called as Government of India Act 1833. What is the importance of this enactment? Again, I beg you, please bear with me for a few minutes. Please bear with me for a few minutes. Why the Indian Penal Code was legislated, you would come to know. The main purpose of this Government of India Act was to unite the entire country into a singular legislative and administrative domain for the British and appoint a Governor General of India. William Bentinck was the first Governor General. He was at that time Governor General, not Governor General, Governor for Bengal only. He was appointed for the entire country, which is equivalent to, in our terms now, President of India, let us say, in equalization. He was appointed as a Governor General of the India to administer the British India. And East India Company was ripped off its monopoly over the trade. You don't require to do the trade activities. East India Company, you should be looked after by the William Bentinck, and only administrative activities will be done. For the first time, native Indians were given an opportunity to do jobs in under the British employment by way of selection. That is how IRS, later years Indian Administrative Service, has been also modeled in the lines of that enactment. So these are the important features. Very most important feature is the Governor General of India, that is William Bentinck, was given the most important function of legislating the laws, isn't it? At that time, there were no laws, only few British laws and native conventions, customs, Muslim laws. Our native personal laws were governing. We do not know for a particular case what law would be applicable. This was in a chaotic situation prevailing in 1833. They felt that it should be channelized. Channelized in the sense entire British India should come under one yoke. It should be ruled by one authority, that is Governor General of India, and he should be vested with the legislative powers. He was given the power to legislate laws. Then William Bentinck has appointed first Law Commission of India. The first Law Commission, now we have, I was told, 22nd Law Commission is now functioning. The first Law Commission was appointed in the year 1833. That was T.B. Macaulay was its chairman. Okay, Macaulay, who is the, under whose chairmanship the Indian Penal Code was drafted. He was the, what do you call, he was the chairman of the, he was the chairman of the first Law Commission, and 4 more members of the Law Commission were also appointed to legislate various laws with which we do not require. The important law is Indian Penal Code. Okay, 1833, why they fell to legislate Indian Penal Code is, as I told, for different types of offenses, there was no regulating single law. They were mostly what you call administered by the personal laws or some other conventions or customs. They thought that it is not good to leave it like that, at least penal laws are concerned. Of course, there is any amount of criticism against Indian Penal Code, which I briefly discuss later. But the apparent objective of requesting the commission to legislate a penal law is to streamline the criminal administrative justice system in the throughout the country. There must have a uniform penal code. For that purpose, 1833, the task was given. Up to 1856, they have toiled a lot and they prepared a entity called as, and this Indian Penal Code, it was submitted to the British government at England in 1856. But I must tell you, in 1857, the Sipahi Mutiny has come, isn't it? The first and great revolution for the freedom. That a Sipahi Mutiny was going on at that time. They have to first of all suppress and subjugate it. Therefore, the entire British government was in that main task, and therefore this IPC could not be brought into force. It was only in 1860 it was approved, and it has come into force 1st January 1862, isn't it? The penal code which we had administered, which had been used by the Indian judiciary, had come into operation on 1st January 1862. It consisted of 23 chapters, and it consisted of 511 sections. Is only for your academic interest. But if you carefully see, the alignment of the sections, If you see the carefully the chapterization over there, the critics, we might not have seen, we have been sailing with the Indian Penal Code, but the critics stated so, it is not a penal code which is meant for a victim-oriented legislation. It is not a victim-oriented legislation. It is not a restitutive legislation. What do you mean by restitutive legislation? Any of the junior advocates, please? Restitutive. Huh? Compensatory. It is not meant for giving compensation to the victim. Nowhere you will find any compensation provided by Indian Penal Code for the victim by punishing the accused. It is only 357 CRPC. If court felt that out of the fine amount, some amount could be given to the accused. It is only a benevolent act like, but not a legislative mandate. So the criticism is that Indian Penal Code was never considered to be, cannot be considered to be a restitutive legislation, nor a reformative legislation. Reformative means to reform the person who was proved to be guilty of an offense. There are no reformative sections in the matter of imposition of the sentence. Sentences are only 5 at that time, isn't it? There are, you all know, one is a death, then is life imprisonment, then imprisonment of either description, either simple imprisonment or imprisonment, rigorous imprisonment. This is the third category. Fourth category is what you call forfeiture of the property. And fifth one is fine. Of these, none will be useful to reform the convict. This is what they felt it. It will be only a sentence oriented. It may called as, it may not strictly be called as retributive, but it is not a reformative type of punishment either. That is what the criticism was. And the second criticism is, if you carefully see the entire gamut of the chapterization and total number of sections, I told you there are 511 sections, isn't it? In 23 chapters. The critics have pointed out that out of 511 sections, almost 1/3 of the sections, roughly 170 to 190 sections, are to protect the interest of the government existing as on today, as on the date. That means from section 121 to 298, 299 onwards starts the offense against the body. It continues up to 377. From 379 onwards, theft to all the offenses against the property, isn't it? Up to 495 or so, 497, of course, 497, 498A, 499, etc. with relation to the matrimonial type of offenses, you may call it adultery, etc. So from 121 to 299, almost 170 sections are some or other type of offenses which have been formulated to protect the government, public interest, public office, army, navy, military, offenses against them. Sedition, most importantly, the very controversial provision is sedition under section 124A. Then even the petty offenses like the offenses against the వేమెంట్, there is any fault in the వేమెంట్ means తూనికలు కొలతలు ఇప్పుడు మనకి separate enactment ఉంది. Even petty offenses which are against the public interest were also made as offenses. So in those lines, they criticized that not almost more than 1/3 of this enactment, the sections in this enactment are intended to protect the interest of the government, that is British government. It was neither a reformative enactment nor a restitutive enactment. This was the opinion. At least in, though not in a public platform, but through the articles, periodicals, and in other uh, 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 meetings, etc. This has been ventilated. Therefore, in the year 2000, the Home Ministry of the country has appointed a committee under the chairmanship of, can I know, what was the renowned committee, famous committee, which has suggested the overhauling of revamping of criminal justice system in India? Malimat. Very good. Malimat, the former Chief Justice of Karnataka as well as Kerala, under his lordship's chairmanship, a committee was appointed to suggest the reforms that they can be brought forth under the three enactments, not only Indian Penal Code. So they have worked for 3 years, 2000 to 2003, and yes, please, 2000 to 2003, and they submitted a what you call a reformation process, a, a big treatise for reforming certain provisions of the Indian Penal Code and also Criminal Procedure Code in the matter of investigation for smooth and effective uh, implementation of criminal administrative system, and also for speedy justice. This is also one of the main motive or motto of this in appointing this committee. What are the important suggestions they have given? It is also important to go now into the BNS, isn't it? Let us quickly look into. They felt that it was in 1860 that was enacted. We are in 2000. By then, we were in 2000. So many political, economic, and scientific inventions were made. This archaic, some of the provisions of the Indian Penal Code became archaic, not able to meet the requirements of the society. Therefore, they felt that it need a total revamping. What are they? Offenses for which death is a punishment, sentence of imprisonment for life without commutation or remission. This was suggested way back in 2000. Death and life imprisonment are there. The life imprisonment may be for n number of years, may be fixed, so that in the meanwhile, no remission or commutation can be given, so that the interest of the, instead of granting death penalty, this alternative and viable measure of punishment can be taken into. This is what they felt it. This was suggested. Where death and life imprisonment are there, life imprisonment with n number of days, some number of years may be prescribed with the court. If you see in recent judgment, Hariharan, I'm really not able to have, the Honorable Apex Court has given a judgment that generally life imprisonment means for the purpose of calculation, for purpose of granting remission, after 14 years, he will be eligible provided his conduct is good in the jail, isn't it? The Supreme Court felt that this provision is being misused, section 433 or so in Criminal Procedure Code. So what they have held is, if lower court gives only punishment of life imprisonment and high court upholds it, then life is confirmed, then it is equivalent to 14 years. After 14 years, he can be considered for remission. But if the lower court, that is the trial court, has fixed, has given him capital punishment, that has been amended, that has been set aside, and instead alternative punishment of him, life imprisonment, is given by the High Court. Then the High Court will have a power to prescribe certain number of years. Life imprisonment, let us say for 30 years, let us say 20 years or 25 years, within which, without completing that period, that particular accused will not be entitled for remission. So what is suggested by the Malamuth Committee in 2003, in recent judgments it has been used. I must say recently, our bench has utilized that provision and given a judgment recently. So this is one of the uh, what you call measures that have been suggested. Next, when a convict commits default in payment of fine, they suggested that community service can be used. See, 2003 they have suggested, 2023 it has come into force now. Way back in 2023, a default in payment of the fine, the court is empowered to impose a sentence of imprisonment for such default. Instead, suitable provision may be made to empower the court to impose community service. Now, apart from 5, the sixth punishment is the community service. Of course, community service is prescribed only in 6 punishments, 6 offenses, but not all offenses. We will now presently look into. Similarly, some other what you call 497 IPC, both man and woman should be punished. It was only man-oriented punishment, adultery. They too felt that there should not be any gender bias. Now, because of the Honorable Supreme Court's judgment, they have totally taken away this 497 from BNS. That is a different aspect. Then a comprehensive and inclusive definition of terrorist act, disruptive activities, organized crimes, economic crimes, etc. may be given. This has been also now followed in the BNS, but IPC, there was no such enactments like terrorist activities. Now section 112 is prescribed in the present BNS. 113, organized crimes. Organized crimes also includes economic offenses. They have given the definition of organized crimes, terrorist acts, terrorist crimes, section 112, 113, etc. in the present BNS. This was also one of the suggestions. So the Malamuth Committee has given very important suggestions. If they hold very latest weapons, for holding such weapons also punishment should be prescribed is one of the recommendations made. Then for tackling serious economic offenses, I told you, economic offenses were also included now in the organized crimes. Then they also suggested that IPC prescribes only limited type of punishments. So punishments variety should be, various other type of punishment should be included. Very interestingly, they suggested community service, disqualification from holding public offices if a public servant commits such offenses. Only under PC Act we will come across the type of making him disentitled for the service if he gratifies himself with a corrupt attitude. If a public servant, I mean, if a public servant acquires assets disproportionate to his known source of income, if any of the advocates who are dealing with the PC Act offenses, you will know better. Then if it is proved, if offense is proved and ultimately confirmed, it will be recommended that he will be removed from the service. But what is the other cases? Means general code cases. If a public servant is involved, the recommendation is that he should be debarred from holding that post. This is one of the modes of sentences prescribed, but even in the BNS also they have not brought forth this type of punishment. Then imprisonment for life without commission or remission, that has been now prescribed. So these are some of the reforms suggested by what you call the commission, Malamuth Commission, isn't it? From 2003, of course, it could not be materialized. Now recently, in 2023, the bill was presented. I need not tell you all the recent background facts. Anyhow, the 3 enactments have come forth. Now coming to the BNS, Bharatiya Nyaya Samhita. What is its importance? And what are the pattern of provisions? What are the important provisions which we have to look into? And in spite of various recommendations, what were not mentioned even in the latest enactment, that also we have to see. And most importantly, what are the criticisms leveled against even the BNS also? We'll quickly look into the salient features. Of course, you know, it consisting of so what are the new changes they wanted to make the new law relevant to contemporary situation act. The parliament has proclaimed that first of all they want to see that the justice should be speedy, justice should be given in respect of offenses against women and children. Stringent punishment should be made. This is another aim. Therefore, certain offenses, particularly offenses against women and children, stringent punishments no doubt are provided under this BNS, that we have to take notice of. Then this is stringent punishment should be provided, make the punishments more relevant to contemporary situations. For that purpose, they have introduced the community service. Then next, providing community service is one of the punishments for the petty offenses for the first time. Then providing new offense on the acts of armed rebellion, separatist activists endangering the sovereignty, section 112, 113, 114 have been introduced. So though they are covered under the special legislations, we have the Terrorist TADA Act, we have the POTA Act, isn't it? In spite of it, why they have been introduced in the General Penal Code is, it was the suggestion made by the, what you call Malamuth Committee, that there are only, or at least some of them are only sunset enactments, sunset laws. What do you mean by sunset laws? After sun is set, we can't see the sun. Similarly, some of the enactments have only short life, a prescribed life. Again, they have to be revived. TOD Act originally passed in 1987 or so. It had only few years of life. It had been again extended up to 1997 only. Thereafter, it was not extended. So its provisions in a different way were utilized. So some of the enactments were sunset enactments. They will live for a short life, but their utility is more. Therefore, it was felt that if in the general law, if in the general penal code, these offenses are prescribed, they will continue forever. This is the very purpose in enacting this BNS and incorporating these type of special special offenses in the general code. Then punishments I told: death, imprisonment, life imprisonment for RI, forfeiture, and now most importantly, community service is included. This community service, we will pause for a moment, because at least tomorrow onwards, for petty offenses, these punishment will be provided, and you have to encounter these type of punishments. How you describe, how you ask the court to give only community service. Just we will have for few minutes the importance of the community service. First of all, I must say, community service, if you happen to read this enactment, that is BNS, or most of you might have already gone through this BNS. Did you find the definition of the community service ever? Did you find at least the explanation remotely what the community service is? Any of you, please? Now, what is community service? But it is, mind it, it is a punishment. It is a measure of punishment in 6 sections. 6 sections they have been provided is, will section 202, 6 sections. Section 202 is, a public servant participates in the business activities. Generally, a public servant should not participate in business activities. he will become an unbecoming of a public servant under service rules. For that, punishment is one. Then section 209, non-appearance in response to the proclamation under 84. If an offender warrant is issued, notice summons are issued, he did not appear, then the court may impose a punishment for the first time as community service. For that also, if he did not, then 84 rigors can be followed. This is one offense. Then what is the third offense? 303(2). If a theft of a property, most importantly, you may come across most of the times in magistrate courts. If a theft of a property less than 5,000 and convicted for the first time, and upon return of or restoration of the stolen property, he shall be punished with community service. That means if a stolen property is worth 5,000 or less, and it is only the first time, and that property is ultimately recovered, but his offense is proved, then the court may impose, instead of a corporal punishment, that means bodily punishment, he can be imposed with the community service. This is one punishment. Then 355, misconduct in public by a drunken person. That is there 505 in the old IPC also. But for that, the offense, the punishment is the community service. Okay. Then section 356, defamation also. For defamation also, the community service is prescribed. So, dear friends, there are 6 offenses for which community service is one form of punishment. Now, the crucial question is, what is the definition of community service? Social service, you may call it, community service, you may call it. It is a much larger, what you call term. It has a larger amplitude and scope to talk about. Everything is a community service. Can a magistrate, or for that matter, a judge, can impose under the garb of or under the umbrella of community service? You, the convict, go to a public office, let us say collectorate, stand by there for 15 days on all the public working days over there. Whoever applicants come over there, you should polish their shoes. The applicants, it's a community service. Is not it? Going to a public office and performing a public duty like. Or you go to a sewerage department and work under the drains and clean the, seeing what you call sewerage, you remove it. Can he or can't he? Can he? If he, why? If he cannot, why he cannot? Is the question. It is also like community. It will be helpful to the community. Or go to a what you call public park and sweep off it every day for 15 days or 1 month, whatever it be. It is also a public service, isn't it? So what is public service? I mean, community service, what not community service is a big question. It has not been defined. But if you happen to read other enactments, you will find a ray of or a contour of what is called as community service. For that, you have to go back to the rules prescribed under Juvenile Justice Care and Protection Enactment. Rule 2 of Rule 6 or Rule 2, if I'm right. Am I not boring you? Must be. This is what. So, this is Model Rules 2016 defines community service. A community service is, in the lighter sense, serving the elderly, maintaining a park, helping at a local hospital or nursing home, serving disabled children, serving as a traffic volunteers, etc. This is for whom? A juvenile in conflict with law above 14 years. Okay, but my doubt, I put it before the August presidency, is whether in the matter of a penal law, in interpretation of penal law, a definition which is not provided in that enactment can be borrowed from a different enactment is the question. Why? Because if you happen to be the student of interpretation of statutes, we will come across that two types of statutes are a class apart. One is penal laws, another is tax laws. Tax laws and penal laws are class apart because they will affect one way or other the life and liberty of an individual so far as penal law is concerned, so far as the property assets rights of an individual so far as tax laws are concerned, isn't it? That is why stamps and registration, income tax act, and other allied acts which prescribe tax, you have to read in between and only interpret. If it is there, he will be liable. If it doesn't there, he cannot be. Maybe crores worth of tax, you can't call it as an evasion. We have to accept the wisdom of the legislation. Now the point is, can we accept this definition from the juvenile justice care and protection rules and employ in it and prescribe only these type of 3 or 4 type of community services? This is one doubt. I'm leaving it for your wisdom to interpret. Another important aspect. See, all the 6 sections I have narrated, it is not the community service alone is the punishment over there, isn't it? Punishment for 2 or 3 years, maximum 3 years, or fine, or this one, what you call community service. You all know that under the Indian Penal Code as well as the present BNS, if a fine is imposed, that fine is not paid, you have an alternative mode of punishment, punishing him. If I remember well, section 57 or 56 of IPC, in that range, you will find that suppose the maximum fine is 1000 rupees, fine is 1000 above, only 6 months in default sentence we call it. 600 rupees or so, or 500 rupees, 4 months, 250 or rupees or so, the fine, 2 months, like that. So a fine can be what you call, in terms of amount, in terms of number of days of punishment can be calculated, can be converted. Okay. But so far as the community service is concerned, if community service is imposed on a particular convict and convict do not want to obey it, how to convert it, how to quantify it in terms of number of days of punishment? Got my point? 30 రోజులు వెళ్ళి పార్కులోనే పని చేయమన్నారు, ఎక్కడా లేదు. గడ్డి క్లీన్ చేయమన్నారు. ఇట్స్ నాట్ ఎ మీనియల్ జాబ్. It will not come back, it will not hit his fundamental right, because the accused and convict are also not denuded of their fundamental rights. Is the law, at least judgment law, by the greatest jurist, Honorable Justice V.R. Krishnaiyer. Okay. But if he doesn't want to do that one, what is the alternative? Alternative is to put him in the jail. Okay. For how many days is the question? Because I imposed 30 days of service, should I say that 30 days you have to spend in jail? For which there is no provision. Apparently, this is my doubt. You may, with your wisdom, find a solution. I'm only throwing open the inconsistency or controversy in this provision. But section 8, please read for your comprehension section 8, 4 and 5 of the BNS, the latest enactment. Even that, what it represented is, it was dubiously saying that if an alternate, if a fine or community service are imposed and that has not been fulfilled, then alternatively he can be punished with the imprisonment. It is there, 8.4 and 8.5. But how you quantify the community service into a particular number of days? This I could not able to, at least myself, I could not able to convert it into a number of days. Hope your cases will not come before me. Okay, in the lighter vein. So this is one apparent inconsistency so far as the community service, punishment of community service is concerned. Please try to read more. Again, at the beginning, I have stated that it is only a neonatal baby, Navajata Sisu. When the GST had come, more than thousands of the questions were lingering in our minds, how to implement. But now the dust has settled to a large extent. Like that, in this domain also, with the days coming, with your thoughtful arguments, this dust will be soon settled down. But as on today, very first day of implementation of this enactment, this is the doubt so far as community service is concerned. Now let us see other important provisions which have been brought forth. Okay. Then we have seen IPC consisted of sections 511, but the present BNS consists of only 358. You may get a doubt whether the remaining 150 offenses have been done away with, and the criminals must feel happy to commit the offenses. No, not like that. The alignment or arrangement in such a manner that except a few offenses, others are still there in the statute book. They have not been repealed or annulled. But in what manner, why and how they have consolidated 511 sections into 358 is, if you happen to look into the introductory chapters, general explanations and definitions chapter in Indian Penal Code, section 4 onwards, section 6 to section 52, very explanation, wrongful gain, wrongful court, general explanations and definitions are given. If you carefully look at, they are given each one explanation given each individual section number. 6, 7, 8, 9, 10, like that, numerical number. But what in BNS they did is, they have put it as a general definition section 2, like in other enactments. All these definitions have been couched as ABCD in that particular section. That is how they saved around 50 to 60 sections. Very few sections have been deleted, like British India, some other archaic sections which will never come across in implementation of this enactment. They have been taken away. But remaining sections are converted into, numericals are converted into alphabetics in a one section. That is how 50 to 60 sections have been taken away. Then some about 37 sections are deleted, no doubt. 37 sections are deleted from which were there in IPC have been deleted. I can give you only few examples. One is section 377, unnatural offenses, that has been deleted because of the Honorable Supreme Court's judgment. Then adultery 497, totally it has taken away, so it is no more in the statute book. Then 478, offenses relating to trademarks, because we have the Trademark Act, that is also done away with. Then 480, using a false trademark, again this will. So these type of offenses have been totally taken away. Then some sections are consolidated. Consolidated means in IPC we will find same offense in different forms are given individual definitions. For example, stolen property. Section 410 is a definition for stolen property. 411, 412, 413, 414. Stolen property definition consisting of a property which is a subject matter of theft, robbery, extortion, dacoity, etc., and obtained by a person can be regarded as a stolen property. This is general. Then 411, 412, 413, you will come across a person who retains a property by way of extortion, by way of what you call robbery, etc., are also specifically shown as offenses. All these type of offenses were consolidated into one section by the new BNS in section 317. This is one example I'm telling. So 410 to 414 has been consolidated into section 317 of the BNS. So these type of consolidation, sections, numerical numbers taken away and alphabetical numbers are given, around 37 sections totally repealed. So in this manner, they could reduce 150 sections. Now that is how we have only 358 sections in the BNS, Bharatiya Nyaya Sanhita. This is one aspect you have to please look into. Then, what are the new sections? This is important. What are the new sections which have been introduced, which were not there in the Indian Penal Code? Let us have a quick look at. Okay, new sections, around 14 to 15 sections will come quickly. Abatement outside India to commit offense in India. This was not there. Abatement was there, but specifically an abatement was made outside India, sitting outside, abetting a person to commit an offense in India. Nowadays, because of the scientific advancement, from anywhere in the globe, one person can easily abet another person to commit India. Therefore, if an abatement was made outside India to commit an offense in India, provided that offense is committed in India, this section will come into play. Section 48. This is newly introduced. Then section 69, sexual intercourse by employing deceitful means. This is very, very important section. Please take note of it. I want to give a judgment also on this aspect. See, we have been coming across a number of cases where a person on the guise of love and marriage will have a sexual intercourse with a woman, and that after discarding her, and she launches prosecution. Naturally, the police will file charge sheet against him, 376, 417 for cheating, etc. Isn't it? A number of decisions, the accused will, what you call, argue. It has been argued also that how the 376 will come into play. This is not neither against the consent nor against the will. It is like a cohabitation. She is not a minor. Perhaps in a given case, she is not a minor also. So there is no question of 370, 376. 417 is also not applicable because there is no what you call cheating involved in this matter. There is no what you call parting of the property or some other thing by virtue of the dishonest and fraudulent acts of that man. So neither 417 is applicable nor 376 is applicable. Therefore, I am not liable for conviction. Is the type of argument advanced? Of course, the Supreme Court has settled this cases in number of one, holding that, look, consent was there in this case, no doubt. This consent was given under misconception of the fact, isn't it? A woman believed a man that he would marry her. Anyhow, they are going to marry. And with that belief, she had a cohabitation with him. But from the beginning itself, that man who induces her to have an intercourse with him, he had no intention to marry her. If the prosecution could able to show this one right from beginning, he had no intention to marry her. It is only to quench his lust. He has made promise. The consent that was given by her is not a consent because it is an exception under section 90 of the IPC. Please look into the IPC. A consent given by misconception of fact is not a consent at all. So the Supreme Court and various high courts borrowed the provisions of section 90 exception 417 and 376 was substantiated. The latest judgment in this regard is, if you want for what you call academic interest, 2019 Volume 13, Supreme Court Cases, page 1. 2019, Volume 13, Supreme Court Cases, page 1. Anurag Soni versus State of Chhattisgarh. In this one, the Supreme Court specifically held, reiterated the old judgments. I could find this is the latest one on this aspect. They held that a consent given by women in the circumstances which we are discussing cannot be regarded as a consent, full consent, because it was tainted by misconception of the facts. Okay. Therefore, that consent cannot be taken to acquit the accused. The legislatures have thought it that in order to ward off these type of arguments and again wastage of the court's time, they have introduced a straightforward section in the form of section 99. What it tells is sexual intercourse by employing a deceitful means. If you have the text, please read it. It is very, very important section. At least I believe it is important one. Whoever by deceitful means or by making promise to marry to a woman, this is important, without any intention of fulfilling, this is another important aspect. He had right from beginning, had no intention to marry her, but deceitful words, he made her to give her consent. Then had sexual intercourse with her, such sexual intercourse not amounting to the offense of rape. Generally, it is not amounting to rape because consent is there. Unless you employ section 90, unless you employ the old section 90, it would not come within the ambit of 90. So the Supreme Court has made it that if a man made a deceitful words and without having any intention to real intention to marry her and induced her to have cohabitation, then it will be a separate offense. No need of looking through the offense of rape or 417 now, from at least today onwards. Sexual intercourse not amounting to the offense of rape shall be punished with imprisonment of either description for a term which may extend to 10 years and shall also be liable to fine. Explanation is important. Deceitful means shall include a inducement for a false promise of employment or promotion or marrying by suppressing the identity. Okay. So this is law has been made stringent. We have discussed earlier that the legislature wanted to impose stringent punishments so far as the offenses against women and children are. This is one piece of legislation in that regard. This is section 69 is newly introduced. Then section 95. Now come to the children. This is of course offense 69. Then section 95 is hiring the children for the purpose of employing or engaging a child to commit an offense punishable with not less than 3 years but up to 10 years. These employing the children, hiring from their parents, gullible parents, and employing them particularly to, I should not say, engage them in pornographic world. This is what has been done in the recent past. Therefore, to eradicate it, this provision has been newly introduced. If a child has been hired and employed or engaged a child, of course, I have not given the full definition of that section. This is the main purpose in introducing this section, which to save the children from this mire of prostitution, etc. This is one section newly introduced. Another important section we have to see newly introduced is mob lynching. గుంపు దాడి అంటుంటాం మన తెలుగులో, సామూహికంగా దాడి చేయడం అన్నమాట. దిస్ ఈజ్ మాబ్ లించింగ్ హ్యాస్ ఎన్ history by itself. It was felt that, of course, in our parts of the areas also, honor killings, isn't it? You might have all heard of honor killings on the ground that a girl or boy loved out another caste or another religion related person they wanted to marry, but one side of the family, either girl side or boy side, did not like it, and in the context of their pride and honor being shattered, committing the offense and killing them. This has become increased, particularly in Haryana, Punjab, Rajasthan areas. A particular community, a particular association was formed to cause these honor killings, and the Supreme Court narrated them as COP, KHAP, COP communities. These COP communities were communities specifically formed to terrorize or to coerce those persons who fall in love and marry as an ideal marriage, but they wanted to thwart it and kill them. These cop associations and causing these type of offenses have increased. The apex court has, in one decision, I may give able to give you that decision, they held that the government has to make a legislation to prevent these type of honor killings. So in this one, a mob lynching is now, of course, you have in the general form of section 141. What is section 141 of Indian Penal Code? Unlawful assembly is there, isn't it? 5 or more persons with a common object. Any person of that assembly commits any offense, remaining persons are also liable for that offense under the constructive liability, isn't it? Or vicarious criminal liability. This is there already, but more pronounced manner, this offense has been introduced. Section 103 2, mob lynching. What it says is, when a group of 5 or more persons acting in concert commits murder on the ground of race, caste, community, sex, place of birth, language, personal belief, or any other similar ground, each member of such group shall be punished with death or with imprisonment for life. This is only uh, to somehow eradicate or to lower these type of offenses. The particular offense has been created and punishment is provided. Then another important section newly introduced, of course, it has not come into force from today onwards, but we have to see. The last one is section 106, subsection 2, hit and run cases, particularly to those land advocates who are dealing with motor vehicle accidents, compensation cases, or 304 and 337, 338 cases. Hitherto, hitherto, what happens is, if a person, I mean, as a driver hits and causes either death or damage or injuries to a particular person or property and goes away, for getting compensation is one type of thing, and punishing him under 304A or 337 or 330 is another thing. So far as compensation realm is concerned, because that vehicle is not there, that driver is not there, only a nominal compensation of how much? 25,000 or 50,000? Huh? 25,000. A nominal compensation under section 163 or so of motor vehicle accident case is provided, attaching liability to the General Insurance Company of India. This is compensation. But punishment is concerned, that man is not there. So to make stringent these type of offenses, to eradicate these type of offenses, what it is made is, if in future that driver is caught, then he will be punished with what? 10 years up to. For general 304A, 2 years or maximum 2 years or 3 years is provided. But because he commits this offense and absconds, therefore the offense is made more, the punishment is made more stringent one and introduced in the form of section 106(2). But I have to quickly add that we have to go back to section 1 of the BNS Act, application of the Act. In this application of the BNS, they stated that it will come into force the day a gazette notification is issued. gazette notification issued for all the offences except 106 subsection 2 because it is under the consideration of the government, because various trade unions and motor vehicle operators, I had off the record, requested the government that not only that particular driver who committed and absconded, even the owner of the vehicle may also be booked by the police. He is a hand in glove or he is an abettor of the offense. Knowing the driver has committed, he did not bring it to the notice of the police. They may also be roped in. They have they have expressed their apprehension. Therefore, we had that this section is not being brought into operation as on today. We have to wait and see. But as on today, this section is not in operation. So friends, these are the new sections that have been introduced. Another important section, section 111, most important. Organized crimes, which we have been discussing, 111, 112, 113 are the most important sections to protect the sovereignty, integrity, and the very administration of the governance is concerned. To protect it, this new section has been introduced. Very interesting to see its definition. Any continuing unlawful activity of kidnapping, robbery, vehicle theft. You carefully look into this one. This section is not against the governance or government, isn't it? It is a section, an organized syndicate of the accused, usually committing, habitually committing general type of offenses, but they are committing in quick succession like habitual offenders. What type of offenses they are? Kidnapping, robbery, vehicle theft, extortion, land grabbing, contract killing, economic offense, cyber crimes, trafficking of persons, drugs, weapons or illicit goods or services, human trafficking for prostitution, collecting ransom by kidnapping, by use of violence, threat. So all these are general type of offenses. These are not aimed against the sovereignty and integrity of the government, but these are all the general type of offenses, but repeatedly committed in a way destabilizing the society, terrorizing the society. Therefore, this was made as a separate offense. Why? Because Malamuth committee has recommended for it. Let there be made as a separate, let there be a separate enactment for this purpose. This section is introduced. 10 years is the punishment prescribed for section 111. It is a new offense which was not there hitherto. Then petty organized crimes, they are the higher level of offenses. These are a bit lower level of offenses. Petty organized crimes are section 112. These are what? This is also a new offense, new section. Whoever being a member of the group or a gang, either singly or jointly, commits the theft, snatching, cheating, unauthorized selling of tickets, unauthorized betting or gambling, selling of public examination question papers, NEET, or similar criminal acts said to commit petty organized crimes. A bit lower strata of offenses than what were prescribed under section 111, isn't it? This is also now made as a separate offense and introduced in the what you call BNS. Then, most important one, section 113, terrorist acts, isn't it? Terrorist acts is also introduced as a separate offense. We have TODA Act, we have the POTA Act, isn't it? Why then they have been introduced? The purpose is this one. Some of the enactments are sunset enactments. They may not survive in future and the government may not find it required to keep such legislations. But the relics of such offenses may continue. Therefore, they thought it fit to keep those offenses in the general penal code, that is general criminal law. That is why this Section 113 Terrorist Act has been activities are being made as an offense and introduced. What it is whoever does any act with an intent or likely to threaten the unity, integrity, sovereignty, and security or economic security of India with an intent to strike terror or likely to strike terror, etc. So this is directly an attack against the very sovereignty, integrity, and very governance of the state. This is a direct attack on the state, unlike section 111 and 12. They are organized crimes, but internal ones against public. But this is an offense against directly attacking the very existence of a nation, very existence of a state, very functioning of a state. So this is a much what you call a grievous offense. Here, one thing we have to think of: the very same offense section is there in section 15 of Unlawful Activities Prevention Act, UPAI Act. You might have heard, isn't it? UPAI Act section 15 also contains the very same offense, very same provision, for which the how to tackle with it, how the court has to conduct trial, who has to take cognizance, very widely given in the UPAI Act. The very same section is also prescribed in General Penal Code or General BNS. Now, you may get a doubt as to which law has to be followed. Suppose a terrorist activity is committed, whether to go under section 113 and book an offense under BNS or to go for UPA Act. UPA Act is also there now in statute books. For that, you please see explanation is provided in this enactment, section 5, explanation to the section 113. If you have, please look into. Explanation to the section 113. It says that for the removal of doubts, it is hereby declared that the officer not below the rank of superintendent of police shall decide whether to register the case under this section or under UPAI Act. Okay. So the discretion is given to the superintendent of police of that area where the offense was committed, whether they should be booked under General Penal Code or General BNS Act or under the what you call UPAI Act. Why then? Some of the advocates, when I was dealing with the very same subject in the Yale University the other day, questioned me, they giving discretion to SP, does not say SP police, is it not what you call, they may not act biasedly? This is one doubt. Of course, we are at the peripheral stage. We have to, the time has to tell, because whether to book a case under General BNS Act or whether to book a case under what you call UPAI Act, the definition is as it is identical. There is no difference between offense of terrorist act under UPAI Act section 15 and section 113 of the BNS. So the superintendent of police will have a what you call discretion to book a case either under this one or that one. But mind it, there is some difference. If you book a case, a preliminary reading I am telling, if you book a case under the UPAI Act, there are some advantages and disadvantages also. The court cannot take cognizance except with the sanction of the government. Sanction is required. But if you book the case under this enactment, we have not found any sanction being required. It is a general law. This is one difference. Punishment, of course, same. Depending upon the gravity of the offense, a death to 10 years, it is there. In the matter of punishment, there is no difference. But the only thing is that in the matter of taking cognizance, a general a sanction is required from the government is one hurdle. That sanction we do not find in this enactment. So the choice is left to him. But since there is no difference in the matter of punishment, sentence, we cannot say that it is a bias. He will be biased, at least for the time being. But the explanation says that the discretion is given to the concerned superintendent of police. You please study uh, for your own comprehension. But bail, bail గురించి ఇందులో ఉండదు కదా, it is only BNS. Again, you have to see BNSS. BNSS లో ఉండొచ్చు, భారతీయ నాగరిక్ సురక్షా సంహిత. అందులో షెడ్యూల్ 1 లో ఉందో షెడ్యూల్ 2 లో ఉందో చూసుకోవాలి ఈ అఫెన్స్. At least I have not gone through. Maybe. Please see it. I have not gone through the bail level, but the basic difference between the two sections, there is no difference. Definition is exactly same, reproduced. And discretion is given to the superintendent of police, whether to choose that enactment or this enactment. That enactment, you need a sanction by the government. There is some step in aid is there. This, we don't find any sanctioning requirement unless BNSS tells anything like 197, 196, 195 CRPC, old CRPC. If it is any there, we have to look into. But I don't think there is such requirement. So this is another new enactment. Section 113, 114, 115 are the new sections that have been introduced. Then important one, section 226. It is a new section introduced. We have only 2 or 3 sections. We can close our session. 226, what it is? Attempt to commit suicide to compel the exercise of lawful power of a public servant. It was not there earlier. Attempt to commit suicide was an offense under section 309. It was there. 306 is abatement of attempt to commit suicide. Those 2 sections were there. Now, attempt to commit suicide is totally taken away. Attempt to commit suicide is no more an offense now, but it's a different format it is given. It is in this form. A person in order to coerce the public authority, ఆ మీద ఎలక్ట్రిక్ టవర్ మీదకి ఎక్కిపోతాడు, లేకపోతే ఇంకెక్కడికో వాటర్ ట్యాంక్ మీదకి ఎక్కుతాడు, నేను పడిపోతానని గోల్ చేస్తాడు ఏదో చేయకపోతే, కలెక్టర్ గారు లేకపోతే అదర్ అథారిటీస్. On and often we will see in the electronic and print media, isn't it? So if this type of, you have other form of making your representation. That is the motto. You have other democratic form of making representation to the concerned authority. You cannot terrorize. You cannot put them in quandary by making these type, what you call, these type of attempts. An attempt to commit suicide with a view to coerce the public authorities to do or not to do certain acts is an offense which is punishable with 2 years or something, 1 year. Fine or both. 1 year or with both or with community service. మళ్ళీ కమ్యూనిటీ సర్వీస్కి వెళ్ళాక అక్కడ కమిట్ చేస్తే ఇబ్బంది. Then you may get one doubt. You may get one doubt as to attempt to commit suicide as it is taken away. Is not it? It is no more there unless it is committed with this type of intention. You may get a doubt when attempt to commit suicide is taken away, whether an abatement to commit suicide is still there in the statute books. Previously 306, that is there. For your kind information, in the form of section 108, if I am right, section 108 says that that is preserved. Attempt to commit suicide may not be an offense nowadays because of his mental conditions and all this he has done. But a person abetting him to commit suicide is still in the statute books. Previously, it is 108, 108 abatement of suicide. So, abetter must be careful. If any person commits suicide, whoever abets the commission of such suicide shall be punished with imprisonment with a description which may to up to extend up to 10 years also, and shall also be liable to fine. So this is one provision which is saved. Then last 2 sections, 304, chain snatchings have been increased nowadays. So chain snatching has been specifically made an offense. Sometimes the chain snatching may cause injury to the concerned victim. So considering the gravity of the offense, gravity of the nature of the offense, the chain snatching has been made a separate offense under 304. Please look into theft by snatching is made punishable with imprisonment up to 3 years and with fine. This is new section introduced. Again, another section introduced is sometimes the mob causing damage to the public property. We have a separate enactment for this purpose. Public Properties Damage Act, or what it is called. Damage to Public Property Act, Prevention of Damage to the Public Property Act, Section 3. It has the same, what you call wording, with the same wording, it has been introduced in the form of Section 324, subsection 3. 324 is now mischief. Previously, it was 427 or so, isn't it? It has now been converted into 324. In that one, subsection 3 has been specifically introduced. If any person commits mischief with respect to the public property, in the names of strikes and all these, causing damage to the public properties, isn't it? To prevent such type of things, that section has been, the substance of that section in section 3 has been borrowed and introduced in this one. The mischief is in the section, in the damage, in the definition mischief, it is introduced. So these are all the sections newly introduced, isn't it? Section 111, 112, 113, section 69, most importantly, offense against women under the promise of, in the promise of marriage, etc. These are the around section 13 to 14 sections are newly introduced. Now just quick look at what are the offenses which have been deleted. Two offenses are most important, but controversy is there. That is what I have to relate to you and close my, what you call, interaction with you. Now look into what are the offenses which have been deleted. You all know section 124 has been, 124A has been taken away. 124A is sedition, isn't it? Sedition has been taken away. It was felt that it was the archaic relic of the British legacy. It is true, if you carefully look into section 124A, a person by making, by virtue of the acts, representation, signs, etc., causes hatred to the established government, incites hatred against the established government, or disaffection against the established government. That in that way it goes, the definition goes. So a person by any manner creates hatred towards that government, established government. In those days, British government. So they wanted to establish, they wanted to stabilize their government. No sort of criticism against the government should be made. Of course, we must add, in the form of an explanation, an exception is carved out. If such criticism is against the measures taken by the government, it will not be an offense. Measures means some acts, some policies. If policies are criticized, it will not hit under 124A. It will not come under 124. It is not an offense. Was that section? But in reality, this, if you happen to read the constitutional debates under this section, what was made is even a honest criticism against the policies of the, of course, British government, it was not tolerated. Even great people like what you call Balagangadhar Tilak, Mahatma Gandhi, Nehru, and so many other patriots were booked cases and they were given punishment. Thrice Balagangadhar Tilak, Queen versus Balagangadhar Tilak. This was the judgment if you happen to read it. Thrice he was booked, Balagangadhar Tilak, because of certain articles he has written in, published in his paper, Kesari. Kesari was the paper. He was publishing from Pune. It was circulated throughout the Maharashtra, including Bombay, wherein certain articles were made. Of course, according to them, these articles are only to criticize the policies of the government then in force, but they felt that it is amounting to sedition. In that judgment, they dealt and confirmed. Yes, your activity is amounting to sedition. Similarly, Mahatma Gandhi ji, he was also booked and he was imprisoned under this section. Okay, so they felt that now that a democratic country we have formed into and the archaics of the British legacy should not be there because there is a chance and scope of misuse, and even after independence it was misused also sometimes, and Supreme Court had to come to the rescue of the those who made only a constructive criticism but not a sedition against the government. So they wanted to totally take away this section. But I must tell that this section in different form, it was again introduced. If you want, you will find in section 152 of the 152 of the BNS. So what was there in 124A was totally taken away, but introduced as a section 152, but not with that rigor. It is the wording used in 152 in a different format. Okay, but it is there. If you say it is not there, we must say that it is there, but not with the vigor as it was there in 124A. It was not there. I may have to recall refresh your memory that when a number of writ petitions were filed against 124A challenging its constitutional this one in 1962, already 5 judges bench has given that it was constitutionally okay because it provides certain exceptions. Constitutional validity will be there even after independence. But now a number of writ petitions are filed, not only the constitutional validity, because of the misuse it is being caused, it may be struck down. A number of petitions are still pending. In May 2022, Honorable Supreme Court has held that this provision shall be kept in abeyance till they referred it to the fuller bench. Till then, it is decided this provision may be kept in abeyance. 22nd May 2022, such an order was passed. To the best of my knowledge, it is still continuing, and I don't know what will happen after 1/7/2024. This is for your guess. What will happen? We have to look into. So this is so far as 124A is concerned, it was deleted. Then next important provision. This is a bit controversial. Section 377, isn't it? Unnatural offense. Unnatural offense. Though a civilized society do not want to discuss in public like this gathering, but still it need to be because certain kind of people, certain kind of people were deprived of their natural life. That is what the Supreme Court felt it in a decision. I'm again repeating that we may feel shy of thinking for those people are no fault of theirs. Those communities are LGBTs, lesbians, gays, bisexuals, transgenders, or a different type of community. God has cursed them. Nature has cursed them. Those type of people have born their expression. A man with born as a male, but with behave like a feminine qualities because the nature has done. A female will be born like a female, but expresses her like a male. This is a what you call mismatching their biological sense and their what you call mental attitude. This is a curse for them. When that is the case, in other manner, in other walks of life, it may not be a difficult thing. We will cope up with them. But only thing is that one way of their expression is their sexual life is also, isn't it? We have to kindly with large heartedness, we should understand it is not like a natural people will having their what you call marital life or sexual life, but it is a different kind of people. Their expression, one of the ways of expression, these are not, please think, these are not the words of mine. These are the words, agony of the Honorable Supreme Court. You believe at the end of the judgment, the Supreme Court, on behalf of the entire nation, has beg excuse of LGBTs, isn't it? For allowing for more than 65 years this archaic provision without minding their rights being violated. For a civilized society, all these things will look like a trash, unthinkable. We don't want to even discuss in these type of platforms, but there are some third gender people are there, how they will behave. Because of their no fault of theirs, they should not be punished by the law also. This is the concern of the Supreme Court. In the judgment, I will tell you, the Supreme Court at the end of the judgment has begged excuse for allowing the penal code to retain 377 without minding that these kind of people will be there. Their way of expression is like this. They are gays. They are lesbians. They, you may call it, they are transgenders. But that is there. It is only recent, what you call a recent innovation, a recent, what you call medical innovation, that sex transmission operations are being performed. Some are failures, some are successes. At least they are now fixed as one sex. They are not what you call bisex, but we don't know what is the percentage of success in performing such operations. That is another aspect. But society has to accept that that kind of people are there, which you know that we will see and come across every day, which we want to hate them without understanding their problem. Their behavior also aggravate our what you call wrath. That is a different aspect. But if you think, this is what the Supreme Court, if you think, you have to accept they are there. You have to protect their rights also. With that judgment, a bill has been passed. What is this unnatural offense? A person commits a sexual act against the nature with the a man or a beast, I mean animal. This is unnatural offense, no doubt. He should be punished. She should be punished for such type of offense. But in the sphere of this section, certain section of the people who have to behave like that only for expression of their sexual life, should they be punished was the concern before the Honorable Supreme Court. The judgment is Navtesh Singh Johar versus Union of India. This was Supreme Court, what you call National NALSA, National Legal Services Authority, raised this question on behalf of the transgenders. Taking pity on them, they filed the petition to declare that this section 377, so far as they are concerned, is ultra virus to constitution. It will go against their right to life. In this judgment, the apex court, keeping in view the rights of LGBTs, that is lesbians, gay, bisexuals, and transgenders, held, this is important. What was held is important. What is missing in the present enactment is also important. Held that section 377 is violative of article 14, 15, 19, and 21 in criminalizing consensual sexual acts of the adults. However, apex court clarified that such consent must be free consent and completely voluntary in nature and devoid of any duress and coercion. This judgment went on only in the context of LGBTs. Or so, because their way of life is that if they are adults, they are consenting parties, then their sexual act will not come as, should not be seen as unnatural offense. Okay. To that extent, 377 was held to be ultra virus because of violating these articles 14, 15, 19, and 21. Only to that extent. But at the same time, the Supreme Court held that this judgment will not protect the rights of, it will not give a free, what you call, passage to those persons with sexual pervertness behave against another adult person or against an animal, which is generally against consent. I may repeat against. This is not a free license. This judgment is not a free license for any persons to behave like a perverted person, sexual perverted person, to commit this type of offense against an adult. Suppose if a man commits this type of offense against a woman, the protection is there under 376. Okay? It is a rape. Suppose a person commits against a person below the age of 18 years, POCSO Act is there, 376 is there. We have the protection for them. If a person commits this offense against what you call animal, the Animal Act, Protection Act is also there, it will be there. This is there. To that extent, it is there. But what happens is the BNS has totally removed section 377 from out of this statute book. In the new statute books, 376, 377 is no more there. In any form, it is not there. It has not been rewritten in a different form. Now, what happens is legal experts, you might have seen in legal articles, the alarm raised by the person. Certain category was taken away, LGBT, okay. Against a woman, adult woman, if a person commits an offense, she is protected under 376. Against a what you call animal, it is committed, animal protection acts are there. Suppose a man, adult man, against his consent, another adult man commits this offense, there is no protection because 377 is totally taken away from the statute book. This is the worrying factor. This may lead to anarchy in the society, at least sexual anarchy in the society is the worryingness expressed by so many professors and so many legal luminaries by removing section 377. Hope I have explained the this section, the what you call the controversy surrounding around the section 377. 377 is totally taken away. That is not the object of the Supreme Court in this judgment. It is only a protection to the LGBTs. To that extent only that section is held to be ultra virus, but not against others, not against the perverted acts of some adult against another adult against his consent or her consent. So please think over and read. If you come across any articles of this nature, understand in this context. Then, of course, the last provision, section 497, adultery. Again, Supreme Court held that in the decision of Joseph Shiney versus Union of India, isn't it? 2019, third volume, Supreme Court cases, page 39. It was held that it was violating the, or it is a gender biased. It is a gender biased. In a case of adultery, is only a man is punished, not the woman. In a number of cases, it was raised, but held that no, a man who entices the woman belong to another person. Therefore, it is offense to be held as committed by the man only. Ultimately, in this judgment, they found that it is a gender biased one. Therefore, it should be removed. They held that it should be removed. They ultimately held it is because it is gender biased one, it should be held unconstitutional, and they have removed. Now in the BNS, now in the BNS, this section is totally taken away. But even without mentioning anything, say, again, adultery is a very sensitive issue, isn't it? For male or female. What will happen to his marital life? If one spouse indulges in the adultery with another man, or one man indulges in adultery with another woman, what happens to the other spouse? It gives rise to a right. See, personal agony, personal feeling of those things are one aspect. But another thing is right to continuance or discontinuance of marital tie is another right, isn't it? That is a civil right. On that ground, they can obtain divorce, adultery, cruelty, desertion, Section 13, so far as Hindu Marriage Act is concerned. Adultery is the first ground on which a spouse can obtain divorce. Now, 497 is taken away from the statute book. There may, again, legal experts are of the feeling that because it is totally taken away, a promiscuous అంటే ఇష్టం వచ్చినట్టుగా కలిసి ఉండడం. A promiscuous life might be led by men and women. The institution of marriage may be at peril. That is one aspect. That is morality aspect. But what is about the legality aspect? Whether the other spouse can obtain divorce on the ground or not, because 497 is taken away. This is one aspect. But we can say that this is only penology has been taken away. Penal offense has been taken away. Civil right to obtain divorce is not taken away. That is a separate relief under a separate enactment that is there. So if one of the spouses indulged in adultery, the other spouse, if can able to prove the adultery, she or he can obtain the divorce. That right is not taken away. Is uh, is one type of argument. I leave it for your thinking and your way of expression. So these are some of the new provisions which are taken away. And the last one is, of course, section 104 of BNS. Previously, 303 it was there, 303 IPC. 303 IPC means if a life convict commits a murder, most probably either in the jail or while he was on parole committing outside. And if it is established, that offense is established, what type of punishment he can be given? He is already a life convict. So invariably, one type of punishment was only prevailing prior to 1983, that he should be inflicted with capital punishment. But the Supreme Court in 1983, for your comprehension, in Mittu versus State of Punjab, 1983, two Supreme Court cases, case 277, held that, look, for any offense, a punishment is given, and that too, an offense of death, sentence of death is there, the judge must have a discretion to impose an alternative punishment, isn't it? Why? Because in Bachan Singh's case, the Supreme Court held that the life imprisonment is the order and capital punishment is an exception. From that exception, they carved out and coined the phrase, what it is called as famous phrase, rarest of the rare. Rarest of the rare was coined from the Bachan Singh's case. Why? Because life imprisonment is the order and exception should be the death penalty, because we cannot retrieve back the life. If ultimately we come across that man is not the real culprit. So life is the only order, exception is the death, but death will be there. They held that it is constitutional, it is not extra constitutional or ultra virus. It is not hitting Article 21 in Bachan Singh's case. They held that 302 death penalty should be there in statute books, but it should be imposed in the rarest of the rare cases. Taking a cue from that judgment, in this 303, in this Mittu's case, what they observed is, you must have two type of offenses, punishments, so that one can select the alternative one. When in the case of 303, you don't have other punishment, only death. So we don't have the discretion. Judges cannot have the discretion. Therefore, on that ground, this 303 is ultra virus to Constitution. From 1983 onwards, but there is no suitable amendment. Now, fortunately, we have an alternative amendment. This is most welcoming one. What is the alternative punishment is, if a life convict commits a murder, death or Alternatively, life imprisonment, they have not left it there. Life imprisonment with n number of years, within which he will not have the opportunity for remission. Otherwise, what will happen? Life convict, he knows that if only life conviction will be given, he will commit n number of murders. Is not it? Therefore, what they held is, while keeping in view the Bachchan Singh's judgment in consideration and also Mitu's case, they have converted the punishment as death or life for a number of years, or till the natural life is completed. Okay. So he will have to be there in the jail till the end of his life. That depends upon the discretion of the court which imposes the punishment. So these are the some of the important provisions I felt which have been newly introduced, which have been deleted, which have been consolidated and concised. Any of your questions, 5 minutes we can spare and then close this session. Any of the, you give the advices to this August gathering. Any of you found any new thing while reading at senior councils? Huh? Any new provision or a new way of interpretation? We will learn. No problem. This is an interactive one. Everyone can. Yes. ఇటు వచ్చి మాట్లాడితే అందరికీ వినిపిస్తుంది. Please.
There is UAPA UPA Act. It's not Sunset Act. It's still there.
Yes.
Others are some Tada, Pota. They are Sunset. Act.
Sunset.
They are
Sunset.
sunset. But UPA is not Sunset UPA. It is there. Alive.
No. Yes. I understood what your point. Yes, please.
Then
Why should they enact again 113 to
Yes.
with
And
the apprehension that
especially when there is no difference, because granting of bail in UPA Act is very much difficult, very draconian. Is it also incorporated in this IPC also to make the bail so stringent, extending the rigor of UPA into this IPC also? Then what will
that's
happen?
why previously also land council asked me this question. For that we have to refer to BNSS. Generally, IPC will not say whether it is bail should be given or bailable or not bailable will be there. But better we have to refer to BNSS, isn't it? Bharatiya Nagarik Suraksha Samiti. Where is the corresponding section? Schedule unda అందులో? This 113 is whether it is bailable or non-bailable by whom,
45D
etc.
and
113.
UPA Act is 45D.
No, in the context of this
Yes,
offense.
yes.
Terrorist act resulting in the death aithe, death or imprisonment for life is the punishment. It's a cognizable offense. Then non-bailable, court of session has to deal. It is made as a non-bailable offense. Non-bailable offense. Relating to 45, what it was held.
45D.
ఏమన్నారు అందులో?
If the court is satisfied that the offender, the accused committed
Has
offense,
not
bail
come-
cannot be.
yes.
Bail cannot be. This way, it is put in a different negative language.
Like in similar, what is that NDPS Act also, section
it is
37.
It was
If
put
in
in
the
negative
opinion of the
language.
court, he has not committed only, bail should be.
The court is satisfied that he has not committed the offense, then bail can be granted. Negatively put it.
Yes.
Suppose that is introduced here also, then IPC cases are also converted in this manner. Especially when this citizen is reintroduced in different language. These two things are very important. There are now agitations going on against these two things mainly.
With regard to the discretion that is given to the superintendent of police
Police.
concerned.
So police are given the discretion. What will the fate of the person if the police are given the discretion is the question.
No, so far as this BNS is concerned, is only made as non-bailable. Non-bailable does not mean even murder case is also non-bailable, but we are getting the bail at a particular point of time, depending upon the circumstances, isn't it? So the Tada offense also, that is my view, at least. Though it is non-bailable offense, at a particular point of time, the court, if satisfies, can grant a bail. But whether the provision under 45 can be imported here or not, that we cannot now tell. We have to further educate ourselves. That is.
But
The
anyhow, my,
45 introduced చేసి bail
Thanks.
deny చేయొచ్చు అంటే that we cannot. Shall we close?
Thank you, sir.
Yes.
Thank you very much, sir, for enlightening us on Bharatiya Nyaya Sanhita. The bar is very much indebted to your lordships. I request all the members of the bar to give standing ovation to his lordship Justice Sri Durga Prasad Rao garu. Now I request the executive committee members to come onto the dais to honor his lordship shawl. Now I request the treasurer of the association to propose vote of thanks.
One more minute. Sorry, thanks, Shabdani. Wonderful, sir. It is a great enlightenment session. We are thankful you too, sir. And on behalf of High Court Advocates Association, I'm thank you, sir. I'm expressing my gratitude to you, sir. And yes. I thank all the members of Happy High Court Advocates Association and all the guests for making this occasion as a great success. Thank you.
The main criticism against the three enactments is its pronunciation itself is difficult. The first and foremost criticism is we are not accustomed to pronounce it. BNS, BNSS, BSA. సో సంస్కృత సమాసాల్లో ఉన్నది
Amma. Thank you. With this today's session is concluded. Thank you, Anandal. I will upload in the our that YouTube channel, and already it is uploaded in the AP High Court Advocates Association.